next 2 minutes. So I request you to use these minutes to share the link with others, to also set yourself ready to listen to this conversation on deadlines for the dead. The dead, as if they have a deadline up to 31st May. So it's going to be an interesting conversation today. Yeah, I request you to share the link with others, to remind them to join as our speakers come on board. I see Master has already joined us, and Mr. Max will be joining us in a few minutes from now. Thank you. Is he reading Dr. Ruvamwini? Yes. Before 31st May 2022 will be expiring on 31st May 2025. So people are wondering what next for those estates. Are courts well equipped to handle whatever application will be coming for renewal, or what to do? Purpose of contest, for those who are not lawyers, actually mean when a person is when a person is dead and has left an estate to be administered, no one can administer it without getting that administration. So that's if the person died without leaving a will. And in case he died while leaving a will, then you get a probate. Or where a person died while leaving a will, but which is a bit invalid due to some errors, you can get as well with the will annexed. So joining us today is Mr. Max, who will be discussing issues related to letters of administration, what to do when they have expired, where to go. We'll also be dealing so much on mission-based judges, or whether courts are well equipped to handle the application which will be coming on board very soon. So joining us today is Mr. Edson Karuhanga, whom I'm hosting with the conversation today. I'll invite him to say hi to us and call on his. Yeah. Thank
you. Good morning, good afternoon, and good evening to everybody who is listening. Welcome. I want to welcome Maxim Mutawingwa, a senior advocate by any measure. I remember when I'm supposed to be an old man, but I remember he conducted some of my classes. So, but a senior advocate, he has been in our courts. He's very well versed with this subject. I think he's known as the Koja of family law in Uganda. He's highly experienced, highly adept litigator. I don't think there's a lawyer who walks into the courts of this country and does not know Mr. Mutawingwa. And he's given a lot to the law, a lot to the education of the law, a lot to the public discussion of the law. And so I think, I'm sure on behalf of those of us on this team and what we call the reggae spaces, sir, for us here, we sing some reggae sometimes. So for us here on the reggae spaces, I think we are honored, we are privileged, we are humbled, and we are grateful to have a senior colleague of your caliber and status joining us to discuss these issues. So I just wanted to start by saying most welcome to Mr. Mutawingwa.
Thank you very much, Edson. Thank you very much, Edison. And thank you, members, for inviting me to this show. I'm so grateful. My name is Max Mutawingwa.
You can't be heard.
I can't be heard?
You can't be heard now.
My name is Max Mutawingwa. Can you hear me?
I think we're having a challenge hearing you on the line. Maybe if we can just work on the sound a bit. Maybe try and say something now.
My name is Max Mutawingwa.
No, you're off.
I'm off.
Okay, just as we're sorting that out, Mr. Mutawingwa will be joining us again very quickly. And as he's joining us, maybe Mercy can say a quick hello.
Hello.
Hello to everybody. Thank you so much for joining us today. Thank you very much for all who have been loyal in calling us over a period of maybe 11 to 15 weeks. Thank you very much for your time. Today is timely, it's exciting, but also it's quite situations they're holding, the estates they're managing, or the properties that are under estates. So they have enough people. So I think it's very important for lawyers who are attentive to learn the next steps they take and to understand the action that you take to protect their interests in the different estates that they are linked to. So please invite your friends, invite your family members to join us because we're going to have a very interesting conversation today. Thank you.
Thank you very much, Mercy. And over to Mr. Mutawingwa. We are very honored to have you here, sir.
Can you hear me?
Yes.
Members, can you hear me?
Yes.
Thank you very
Yes,
much,
we can.
Edison and team. Thank you very much for inviting me. I have already been introduced, but I will introduce myself again. My name is Max Mutawingwa. I have been an advocate of the High Court since 1998. I got my first PC in 1998. And as you have heard from Edison, I have really practiced through, because from the time I got my PC, I hit court, and I don't think there is a day where, I mean, when I have not gone to court. And also I represented the Red Paper newspaper, which had so many cases, and I did that for 19 years. So really, I always tell people that if there is an advocate who has practiced his profession, it is me, and especially in court. So I'm well conversant with these issues, and I'm very happy to be here to discuss this important topic with you.
Thank you so much. When you said 1998, I realized as a social person before I was even born. Don't count my age, those who understand. But now, and you mentioned you have been using Ready Paper.
Yes, yes.
Before you even go deep into conversation, the moment I add that headline, the rule of law is goodbye rule of law, that is
Yes.
of the amendment of the UPD.
Yes,
Act.
yes, yes.
And looking at how the act is, and people are saying it's trying to silence people into talking. And before even you go deep into the state, sorry, go deep into the space, I would like you to have your opinion, like to assess the current state of rule of law in Uganda in light of the recent amendment, and how it affects national security and also certain civil oversight and probably freedom of speech for people. Before we even start speaking a lot, we may be called by the same act.
Thank you very much. The issue of rule of law is a very delicate issue in this country to talk about. But I always tell people that I speak without any fear or favor. And of course, everybody is concerned about the state of rule of law in this country. And maybe for non-lawyers, rule of law is a concept that ensures that all individuals, all institutions, and all government officials are subject to and accountable to the law. So everybody follows the law. So what is the current state of the rule of law in Uganda? Previously, we have been having some reasonable level of rule of law. But I can't say that we still have that level. The rule of law in this country has degenerated, and not only in matters of the court martial. As who are advocates, we are meeting so many challenges, especially in non-matters. You have seen nowadays in court, when you go to court, you win a case, the matter cannot be, you cannot execute the matter. There are some roadblocks. Example, the RDC, you want to execute, but you have to seek the permission of the RDC, and it's not anywhere in the law. Then the police, also they have a land unit. You have also seen the State House land unit, and it is not only one land unit, because there is one unit at Mengo, then there is another unit at the Okero House. So all those units, they are eroding the rule of law. Everybody is doing whatever he wants, and which is not provided by the law. You have seen arrests, torture, and now almost everybody is scared. People who are tortured, they go to court, they cannot get bail. So there is a lot of fear in this country, and people fear talk. I don't know where we are going to end. So members, the rule of law in this country has degenerated, as you may well know. And this degeneration of the rule of law, national security, actually it brings insecurity, because if there is no rule of law, we cannot get justice, we cannot get peace. So it does not help the security of the country, it does not help the security of the citizens. And now we are sliding into a state of anarchy. So the government has to do a lot to ensure that we return to the rule of law as quickly as possible. Thank you very much.
Thank you. Thank you very much for that.
And for the court martial, maybe I can add the court martial. This rule of the court martial, actually I was asking, I have been seeing it on social media and on TV and in print media. People have been going to parliament before the passing of the UPDF Act. And I was wondering, why haven't I been called? I wanted to be called personally. I wanted to be invited personally to go there, and I tell them my mind. Because I saw the Attorney General was advising Parliament that the Supreme Court did not prohibit the court martial from trying civilians in the court martial. And I don't think he was doing right. And I was telling my friends, and even on the social media, that really, why haven't I been invited? So that I go there and tell them. So at least now I'm happy to be here. I can tell you my mind. The Supreme Court was very clear. Even before that, you see, the court martial is not a court. It is like a tribunal. It is a disciplinary committee. And actually, each discipline has its own marshal. Like we lawyers, we have the law council. It disciplines us. If you steal the client's money, they take you to law council. Even in the police, I always appear before the police tribunal. Some policemen have been charged there, and I have represented them. Then the army also, similarly, they have the court martial. And primarily is to deal with the discipline of its soldiers, of its members. But it is not a court. So importation of the civilians to be tried in the court martial is illegal. And you have seen very many people have been trying to fight it. I remember the case of Sejusa. Sejusa, I think he was the one who first challenged it. Actually, I represented the Sejusa at one time when he had the problem with the army. I represented him before the court martial, and I represented him in court. And then now comes the case of Kabaziguruka. All those people have been trying to challenge the court martial. And finally, we have a decisive judgment of the Supreme Court, which clearly states that the court martial does not have any authority, any right to try the civilians. But now, after the judgment of the Supreme Court, hurriedly now, a bill has been introduced in Parliament, and you know how quick it has been. At a supersonic speed, they have passed it. Now it is law. It is waiting for the president to assent to it. After the president has signed, and of course he will, it is going to become law. And that law is going to bring problems to this country because I think they are making it for a purpose. Because there are people who have been being tried before the court martial. And when the Supreme Court made the judgment, they were not released. Actually, the Supreme Court made a mistake. It should have said that all those people who are being illegally tried before the court martial should have been released. But they were not released. So they were kept in prisons. Now it appears as if they are making a law. And after the law is assented to by the president, now it appears they want now to bring back all those people who are being previously tried before the court martial to the court martial again, which is very wrong because the law does not act retrospectively. So I don't think, maybe it is not going to happen, but if it happens, it is going to be very absurd because all those people who are being tried before the court martial, they are not supposed to be brought back. The law can start from now onwards. It cannot go backwards. So this UPDF Act is a bad law. It has been made to defeat the judgment of the Supreme Court, which is very unfortunate, and it is not going to bring peace. It is not going to bring stability in this country.
Thank you. Thank you very much. For that very explicit answer. Now I want us to go into our topic for the day. One of the things as we're talking about rule of law, that many people are interested in this subject of the letters of administration. But before we start on the letters of administration, maybe if we could just hear from you, Maxim, if you could just, because many people are listening, there are issues to do with estates. They want to understand them, but they also don't understand these technical terms. So if you could just break down for us what letters of administration are, for those who are listening and don't have a legal background. There's also grant of probate. What is grant of probate? What is letters of administration? How do each work? Basically, if you could just give us a bird's eye view of this, such that many of the listeners who have maybe estate issues or who are following up on this subject but don't have a proper understanding of the difference between these terminologies, if they could just understand them so that we can have a proper understanding of them.
Thank you very much. Thank you very much. Now, I will use examples to explain the difference between property and letters of administration in the estates of the deceased. So, when a person dies, he can die in two ways. He can die in two ways. He can die when he has made a will, and he leaves a will behind, a valid will. So, in law, we say that he has died testate. He has died, he has left a will, he has died testate. Then, a person can also die, but he does not leave a will behind. Then we say he has died intestate. So somebody who leaves a will behind has died intestate. Somebody who does not leave a will has died intestate. So, what is probity? If somebody dies and has left a will, then in most cases, the will provides for executor. And the executor who is provided in the will is the person who is going to put that will into effect. That person is always written in a will and is called an executor. So when a person dies, tested, having left a will, he needs to go to court to get a grant. And that grant or authority to administer the estate of that person who has left a will. He will apply to court, and for him, he doesn't go to Administrator General if the will provides for executor. He applies to court directly. Then, after the legal procedures of court, he is granted a document called probity. That is what we call probity, a grant to a person for authority to administer the estate of a person who has left a will. Then there is now letters of administration. Letters of administration refers to where a person dies and has not left a will. If he has not left a will, then he needs to apply for letters of administration. But he starts with the Administrator General. He first has to report death to the Administrator General. Then the Administrator General, there are procedures which take place there. Then the Administrator General gives him or her a certificate of no objection. After the certificate of no objection, that person applies to court and is given a grant called letters of administration to administer the estate of the deceased in accordance with the law, because there is no will. And the person who has left a will, who has got the probate, his estate is managed in accordance with his wishes, which are stated in the will. But maybe there is another category. Somebody has died, has left a will, but the will does not provide for executor. So if somebody dies and has left a will, a valid will is a will which is duly signed by the testator, the person who has made it, and is duly witnessed by two witnesses or more. Very many people have a problem, especially the non-lawyers who are listening. Recently, I have come across cases where people make wills and they keep them, they think that they know the law. A person makes a very, very good will, especially the Bazeis. He makes a very good will and then he puts it under his rock. So when they get it afterwards, you find it doesn't provide for the signatory. The witnesses are not there. So that one is not a will. I have encountered many. So if somebody now dies, leaves a will with no executor, then now his beneficiaries of the estate must not apply for probate now, though there is a valid will, but they apply for letters of administration with the will annexed. Those are the three categories. So letters of administration refers to somebody who has died and has not left a will, and he applies to court for a grant to administer the estate of the deceased. Then probate refers to where somebody has left a will, which provides for executor. And when court grants that authority, then that person starts administering the estate of the deceased. That's how I can explain it.
So maybe just a quick follow-up. Just for people to understand, and for people to have a quick understanding, in either of, you made it clear that while people die, and there's one thing that happens to them, they die. In law, you are saying they can die in two ways. They can die having left a will, or they can die having not left a will.
Yes, yes.
And that if they have, and that still there are three ways. But is it correct to say that in every way that you die, legally, legal death, whether you die with or without a will, or whether you die with a will without administrators, without executors appointed, is it correct to say that in all instances of death, court is involved in the distribution of the property?
Yes. Thank you very much. Of course, after death, legally, court in the administration of the estate of the deceased. That is legally, but of course, you know, in this country, very many people, they don't follow the law. Like I can give you an example. May I come from Tungamo district. I think the high court is in Mbarara. Mbarara from Tungamo is let me 60 is 85 kilometers. So to reach high court is 85 kilometers. So when a person dies, and in most cases they don't have registered land, they don't have a bank account. For them, they divide the estates. They don't know even about the administrator. So that one is divided, but is done illegally. But that is what is pertaining mostly in this country, I can tell you. Very many people don't get letters of administration. But the legal way, whether somebody has died with a will or without a will, the legal way to administer the estate of that deceased is by obtaining either probate or letters of administration. Otherwise, if you do it without any authority of court, we call it intermeddling with the estate of the deceased, which is a criminal offense. So in any way, you must go to court to get authority to deal with the estate of the deceased, to manage the estate of the deceased, to distribute the estate of the deceased. And the law states that when somebody dies and you get a grant, you are supposed to file an inventory in 6 months, and then in 1 year, like this, you should have divided the estate, and you make a final account to court. You wind up the estate, but that is not what is done in this country. Maybe we are coming back to that one.
So intermeddling is a crime. If you are there dealing with estate property, you are intermeddling and committing a crime. Alfred, any questions?
Yeah, I was getting to that question. That now someone died, he left a will. I applied and I was granted probate, or I was granted as administration with the will and next door justice as administration. So now I have this grant. As the person with that, now I'm the administrator or I'm the executor, what am I supposed to do with this grant? And what are the timelines for doing whatever I'm supposed to do? Do I just sit on them as if I become permanent and pensionable? What am I supposed to do with this grant as a person who has received? Yes.
So thank you very much. After getting the grant, of course, the grant is granted to the administrator for a purpose. It is not given to him to keep in his drawer, but it has a purpose, why it is granted to him. And the purpose is one, to administer the estate of the deceased, which includes dividing it to the beneficiaries. And even there is a timeline when the administrator is supposed to do it. For example, when somebody gets a grant, whether probate or letters of administration, within 6 months, he or she is supposed to file an inventory in court. An inventory is a list of the properties of the deceased, which he has found, which has come across. He makes that list. He can say, I have found these plots of land, the deceased had these dates, the deceased had these creditors. So that list is called an inventory, and he's supposed to file it in court within 6 months. So when he gets that grant, he's not supposed to sit down. No, he's supposed to trace the properties of the deceased. He's supposed to trace the dates of the deceased. He's supposed to trace the credits of the deceased. Within 6 months, file an inventory in court. That is mandatory. If you don't file an inventory in court, then it means you have to file an application so that court extends time for you, for the administrator, to file that inventory. And as you may have seen now, as you may know, there are so many applications after the enactment of the Succession Amendment Act. People never used to mind. People used to get the letters of administration. Others would sit on it for 20 years. I was talking to somebody today who got letters of, his father got letters of administration in 1986. 1986, I was in Senior 1. Imagine, I was 15 years. But now, that person, that administrator has never distributed the state. The state is there. It is not yet distributed. You understand? Yes. So, an administrator must not sit on the grant, but he must use it to administer the state of the deceased. So, in 6 months, file an inventory. Then, even there is a time limit within which to distribute the state, and that is 1 year. Within 1 year, you should have distributed the state and filed the final accounts in court. If somebody you say, I have divided the plots of land, this land I have given to Edison, this land I have given to him, and then you make a list, and even the people, the beneficiaries sign, and that list, you file it in court, and then you wind up the state in 6 months, in 1 year, the state should have been finished. But what is happening now? People get grants of letters of administration, grants of probate, and sit on them, and it has been going on until the enactment of this Succession Amendment Act, number 3 of 2022, which now introduced the lifespan of either probate or the letters of administration. You get probate, you get letters of administration, it has a lifespan. If you don't use it in that time, it expires, and then you are supposed either to apply for another or to apply for extension of time of this grant.
File the inventory within 6 months, and then if I don't file the inventory within 6 months, is it a crime? Then another thing, what am I supposed to file after the 1 year after disputing the state? Then there are circumstances where the deceased left the title of the land. What am I supposed to do? What am I supposed to do also now as the administrator of the state? Before we go to that question of the expiry bit of it.
Yes, about to whether failure to file an inventory is a crime. I have read the Succession Amendment Act. I don't think failure to file an inventory has a penalty. There are crimes which are specified in the law.
Yes.
But I don't think failure to file an inventory is a crime.
Yes.
But if you want to file an inventory, you have to apply for extension of time. Maybe crimes are like intermeddling in the state of the deceased. Like I have seen even this one, and I'm very happy with it. There are some lawyers who have been conniving with the administrators to steal parts of the estate. Like I saw some lawyers, they would make agreements that I'm going to help you get a grant from court, and then you will give me 20 acres. I saw somebody who got 50 acres. A lawyer, imagine, because these people, they don't know the law, and they are very poor. A lawyer got 50 acres of the estate to apply for a grant of letters of administration. A grant of letters of administration, which takes like 1 million. But imagine a lawyer has taken 50 acres. So you see, it is ripping off, and the people now they ride on the ignorance of the other people to cheat them. But failure to file an inventory, I don't think it is a crime. The crimes are specified in the Amendment Act, and there are many. Yes, but I don't think we have time to go into all of them. Then what was your other question?
Yeah.
Yes.
Then the other one was if the deceased left titled land,
Yes.
what am I supposed to do before distributing?
So if the deceased left titled land, upon getting the letters of administration, the administrator or the holder of property is supposed to distribute the land amongst the beneficiaries, but he cannot do that unless and until he has first registered into his names or her names as an administrator.
Yes.
So the land has first to be registered into the names of the administrator, and that is when he or she will get authority to distribute the estate. And after that, then the subdivisions is subdivided, and each one gets his or her share. But I have seen even in some instances when the family, you see, the most important thing is the consent of the beneficiaries. Yes. I have seen in many cases beneficiaries sit and agree There are some land which is not divisible. You find it is very hard to divide. So they say, can we sell? I have seen some lands being sold, houses are being sold, and then instead of dividing the land, they divide the money. But the estate has to be wound up.
Yes, yes.
That is what the law says.
Okay. There is, excuse me, you've spoken extensively about the new law, and there is a growing public concern about the expiry of letters of administration and the lifespan. And maybe you could first take us into that. What are the consequences of prolonged inaction by the administrator? But also, people, I think there have been news stories that people are losing their properties and things like that. What is the effect of the expiry of the grant? If, for example, the title has now been transferred into names of an administrator, and then the letters of administration expire, I think one of the concerns that we are seeing from the public is the property has expired, so to speak.
Maybe just to add to Francis's question, we need even maybe also when do you start counting the days of expiring? Like if my grant was issued on, because they are saying grants which were issued before 21st May 2022 are expiring on 31st May of 2025. So if my grant was issued on 1st May 2022, does the 3 years start counting from 1st May 2022, or they started counting on? Does the 3 years start counting on when the grant was issued, or they started counting on 31st May 2022?
Yeah, so basically, the 3 years also just explain
Yes.
to us,
Mm.
to the people, what the 3 years are, what the expiry is. Yes, there's so much interest, and there's people also need to understand the terminology.
Thank you very much. Before the coming into force of this Succession Amendment Act, as I have already said, people used to be granted letters of administration, they get grants and they sleep. People have been sleeping on the grants for 40 years. They still have grants and they say we are administrators. So you administer the state in perpetuity. So, which was very, very wrong. So now Parliament came with a law now, an amendment to the Succession Act. And this law is called the Succession Amendment Act number 22 of 2000 and, Succession Amendment Act, Act number 3 of 2022. And that act amended the Succession Act. Succession Act is the act which concerns the estates of the deceased. And the law is very clear. The question you have asked me, the law is very clear. It is not ambiguous. It is a question of mathematics. Now, this section is here. Section 341, subsection 2 of Succession Amendment Act. It is very clear. Let me read it even for the listeners. A grant of probate or letters of administration issued by a court of competent jurisdiction before the coming into force of this act shall remain valid for a period of 3 years after the coming into force of this act. Have you understood?
Yes.
Shall remain in force. Shall remain in force for a period of 3 years after the coming into force of this act. So, after the coming into force of this Amendment Act, that grant which was issued before the coming into force of this law would be valid for only 3 years. So, when did the law come into force? This law, and that is where the problem is coming from, that's where people are not understanding. This law came into force, you see, date of commencement, 31st May 2022. So you understand? So this law came into force on 31st May 2022. So it means every grant which was issued before this date will live for only 3 years. So the 3 years will expire on 31st May 2025. So that one refers to grants which were made, which were granted by court before the coming into force of this, before the 31st of May 2022. And 3 years will expire on 31st May 2025. All those grants will totally expire. And they won't be valid and nobody can use them. So you are saying, what if I got a grant after? If you got a grant after this, then there is another section, and that section is section 54 of the Amendment Act. It is here. Section 54 of the Amendment Act, and it amends Section 258 of the Principal Act. What does it say? A person to whom probate is granted under subsection 1 shall carry out the duties and functions authorized by the grant or probate for a period not exceeding 2 years. So any person now who gets a grant after this law comes into force, after the coming into force of this law. So from 1st of June 2022 onwards, now we start counting. It is a question of mathematics. You count on the 2 years. So if you got a grant on the 2nd of June 2022, your grant will have life for only 2 years. So upon the expiry of 2 years, your grant expires and it cannot work. So I think you have understood the differences. So the difference is between grants which were made before the coming into force of this law, before the 31st of May 2022, and then the grants, those ones are for 3 years. Then the grants which were made after the coming into force of this law, after the 31st of May 2022, those ones expire after 2 years. Yes.
Now that my grant has expired,
yes.
But I have not administered the state.
Yes.
What is my fate? What should I do? What should I do? Should I apply for extension? Do I apply before? If I'm applying, should I apply before the grant expires, or I can even apply after it has expired? Because now we have 10 days. For if I got before 31st May 2022, yeah. So it means it's expiring on 31st May. It's yes. 10 days. It's actually 9 days. So should I apply for extension before, or I can wait and I apply after?
Actually,
and I think before you can take that.
Yes.
I think the same question applies to, there are people who maybe were incapacitated as administrators, and we'll come to that question after. Maybe we'll first deal with this one, but there are people who have been administering estates for 40, 50 years. Since the 70s, somebody is the administrator of the estate since the 70s, the 80s.
They are still having their
There are people who had children in 2000 and died, and they left infant children, and now they're in their 30s and their mothers or fathers are still administering estates. What we are hearing, and what many people are hearing and are getting worried, is that in the next 8 days, in 9 days, in 1 week and 2 days, what's happening to those people? I think that's the question they need to know. And then what remedies, what can they do to salvage whatever may be happening? And as you're coming on to answer, just allow me to welcome all those who have joined us. We've taken what I would call a break from our usual programming to discuss two matters. We've handled one very quickly on the rule of law, and we're now delving deeper into this issue of expiry of letters of administration. And we have with us Mr. Maxim Mutabingwa, a senior advocate by any measure, called to the bar in 1998, and who has walked the courtrooms of this country extensively, and is certainly known to every lawyer. So, over to you, Maxim.
Thank you very much, Edison and team. So now the question is, now what happens after expiry, isn't it? After the expiry. Now, these 8 remaining days, are they? Yeah, actually there are 8 remaining days. So what if somebody does not apply for extension within these 8 remaining days and the grant expires? So now the issue, actually, how you have right, you have asked a a very good question. Recently, I was in court and I was appearing before the registrar for identification. The registrar warned my client that you see, this grant expires, and you, if you want the extension, you must apply for extension before the grant expires. That if a grant has expired, it is as if somebody has died. You cannot resurrect him unless maybe you are Jesus Christ. So you have to apply, according to the registrar, you have to apply for extension before the expiry of the grant. You understand? But now let us go to the law. Let us go to the law. Now, these grants which were made after the coming into force of this law. Now, extension is governed by Section 54, subsection 3 of Succession Amendment Act, which amended Section 258, and it states, notwithstanding subsection 2, court may, on application, extend the period prescribed in subsection 2, this period of 2 years, may extend the period prescribed in subsection 2 for a further period of 2 years, or any other reasonable time as determined by court, if it is satisfied there are conditions to fulfill. It is not just a matter of applying. So your question is very direct. Now, can somebody apply for extension after the expiry of the grant? My own opinion is that a person may not be able to apply for extension after the death of the grant because it has died. Then it means the person will have now to apply for it as for administration afresh. That is how I understand it. So these 8 days now, if somebody wants to use the grant, he has to apply within these 8 days. So that by the time of the expiry of the grant, there is a pending application for extension. That's how I understand it, and that's how the registrar explained to us. But the interpretation of this law, I don't know really whether because the law is not very clear. The court may, on application, extend the period prescribed in subsection 2 for a further period of 2 years. So, but now if I have a grant, I have it on my table. Yes, it has expired. Can't I apply for extension? Because it is lying on my table. But the registrar told us that once, and I think it is a maximum of law, once something has died, you cannot resurrect it. You have to start afresh. So my opinion I'm giving on this is that once the grant has expired, it may be hard to apply for extension. So you apply for extension before the what? Before the expiry of time. Within these 8 days. So that's why there is a stampede. Everybody now is stampeding. They want to apply for extension before the expiry of their grants.
And I'm going to come to the stampede shortly. Equipped to handle the sort of the number of applications and the sort of backlog that will come. But before that, my colleague Basi Chebutai has been on, waiting and dying to shoot a question here. So Mercy, please shoot.
Yes, my question is just in line with what he has just mentioned. So we have scenarios where we have administrators who have already been registered on titles, for instance, and if we are saying that we would have to go by extension within these 8 days, or they would have to reapply, that means what happens to the titles which are already in the names of those named administrators, and then you have someone else apply for these letters of administration and they are granted. Do you think that the people who are amending this law took this into consideration? And also keeping in mind the surge in these applications in the different courts, do you think the courts have set up a unique or made program to deal with these applications for renewal and managing the estate so that we don't have, first of all, fraudulent cases that are going to come up? We're going to have people mismanaging estates. We're going to have people making rash decisions, and even educating the masses, because some of these administrators, most of them are not lawyers. Most of them are in these remote areas. I don't know, from your perspective and your experience, have they put in enough effort in educating the masses and ensuring that they're aware of their responsibility and the action they need to take now in the next maybe 8 days?
Okay, over to you.
concern is people who have been appointed administrators and they have already been registered on the land as administrators, but they have not, the grant has expired. The grant has expired before distributing the property. You see, that's how it has been even. Somebody has been appointed an administrator and is already registered on the what? On the what? Do you know even now as we talk, you cannot even distribute the property if you have not filed an inventory. If you have not filed an account. It is the same thing. Because you have first now to apply for extension of time to file an inventory. Then, you see, even this is very serious. They cannot give you even, they cannot certify your grant. If you are not, you didn't abide by the law, they cannot certify your grant. So you have first to apply for extension of time to file an inventory. Then you also have to apply for extension of time to file an account. So now, how do you apply to file an account of a grant which has expired? It is self-explanatory. The grant has expired already. And you see now we have been applying for extensions because the grants were still alive. But now the grant is dead. You might find that you have to apply for another grant. Maybe Parliament did not think of that one. But you have to apply for another grant. Because your grant has died. And even you cannot apply to file an inventory of that grant which has already expired. Or even you cannot apply to file an account of the grant which has expired. You have first to deal with the grant. So you might find that now it will be done by a new administrator, maybe. It's self-explanatory. Maybe when Parliament was making this law, they might not have thought about this scenario. But it is
maybe the next question goes to, it takes about a year to get letters of administration from the court, on average, I think. The next question is, other courts, because if you go up-country courts where the judge is the civil division, the commercial division, the land division, the family division, the criminal division of the High Court, you have a judge in Mbalala, for example, handling all the matters all the way to Ntungamo of criminal, civil, divorce, letters of administration. Has Parliament placed a burden on the courts in estate matters that is really too heavy to carry already? Because now, if it means that from the moment we get off, I can tell you we have about 1,000 people listening right now. From the moment we get off up to and for the next 2 days, a lot of business is going to walk into law firms because people are going to flood the firms to make these applications. In your experience, do you think the courts are currently equipped to handle this sort of situation?
In my opinion, and as a person who uses court daily, I don't think court is well equipped to handle this scenario because you may agree with me, court is already burdened with a backlog of cases. We have so many cases which are pending in courts. I think it was in February when there was opening of the new law year. I attended the ceremony at the High Court and the speech by the Chief Justice. Actually, he gave us his speech, and I have it. The backlog of courts, he said, now, if you look at all High Court divisions and circuits, as per 31st December 2024, the backlog of cases in the High Court, circuits and divisions in the whole country was 27,264. That's the backlog in the High Court. What is a backlog? A backlog case is a case which has been in the system of court for 2 years and more. So you find cases are in court for 10 years. Like yesterday I was handling a case which has been in court for 10 years and we are still proceeding. But backlog refers to cases which have been in court system for 2 years. So the High Court in the whole county and all the divisions, the backlog is at 27,264. Then the Chief Magistrate's courts, the backlog was at 8,333. Then the Grade 1 magistrates backlog was at 2,489. The other day I was appearing in the High Court. The judge told us that he has 90 judgments and rulings to write, which are pending. All the cases have been had, submissions have been filed. Now it is waiting for the judge to write the judgments and ruling. 90. Imagine, Edison, you have 90. You have on your table 90 judgments to write. When will you live a life? So now, in addition to that, we are now getting this stampede. Almost everybody is going to file, because imagine Edison, people have been getting letters of administration from way back in 1970s, 80s, but they have never divided the states. And in one way or another, you'll find that letter of administration is necessary. You find now there is compensation, the government is building a road, they start fighting over money. They need the letters of administration. So in one way or another, that grant is necessary. So all those people now, they are going to fight for what? For grants of letters of administration, or in these 8 days, they are going to file application for extension. The court cannot handle that one. Like I always go to family court. Even now, I have applications which are pending, and they have been pending for about 4 months, 6 months, just to get an extension of time to file an inventory. Even sometimes you find you have an inventory, but you cannot file it because you have to apply for extension of time. So the court is overburdened. They cannot handle it. So this surge, this stampede, this court system cannot handle it, and I don't know what we are going to do.
We had made a suggestion here. If you look at, and I know we had said we are interrupting regular programming, as they call it, but we had made a suggestion here about Article 142.2 of the Constitution, which provides that where the state of the business of the High Court or the courts of judicature so requires, where the court is overwhelmed by the state of its business, there is no harm. Actually, they don't say there is no harm. I think it allows for the Judicial Service, for the President, on the advice of the Judicial Service Commission, to appoint advocates on an ad hoc basis to come in, help clear backlog or help resolve a business issue and move out. Of course, since 1995, this provision of the Constitution has never been applied. Do you think that this is something that should seriously be looked at? And also, the other suggestion people are making is technology. Do you think that if the court continues with business as usual, is it able to handle the burden the legislature has imposed upon them and in effect upon many estates in the country?
Thank you very much. As I have already stated, if court continues its business as usual, they cannot handle this magnitude of cases. They cannot. They are already failing. I have given you the statistics. They are failing. Imagine a case takes 10 years and it is still in the court system, and we are still moving to court. It cannot. Now, they are creating now more. So how can it manage? It cannot manage. So that Article 142, maybe it should be handled, but I don't think even the Judicial Service Commission will make a precedent, because precedents in this country are very hard to make. Now, we have been crying, we advocates, we have been crying of the backlog, and we have been saying, why can't the government appoint advocates on temporary basis to handle these cases? But now who has been appointed? Now they have appointed mediators now. Do you know the mediators who have been appointed? A judge retires from the Supreme Court, from the Court of Appeal. Do you know the retirement age? The retirement age of Court of Appeal is 70. 70. They have been appearing before judges who are mediators now. They have appointed them as mediators. Instead of appointing young men, let me tell you, Edison, a person of 70 years is old, I'm telling you. 70 years is so old. He's frail. So now even if you see how they are handling the mediation, they are already old. Those people should retire, they go to their cows and graze, maybe they go and tend to their grandchildren, but they shouldn't be in the court system. When will they live a life? They should live at least the last evening of their lives at their home. So now if the government it could appoint young advocates. It could appoint young advocates, but also now appointing these young advocates also will create a problem. I have been having a problem with the Judicial Service Commission, and now it is coming back now to me. The Judicial Service Commission, actually the one which has brought all this backlog. How? The Judicial Service Commission is the one which appoints judges and judicial officers. And there is a way they should appoint them. And there is a certain caliber of advocates, of judges and judicial officers who are supposed to be appointed. But what do? They appoint incompetent judicial officers. They appoint irregular judicial officers. They appoint corrupt judicial officers. There are three problems: irregularness, incompetence, and corruption. And how does it come about? A person applies to be a judge or a judicial officer. You apply. But shortlisting, you don't know the criteria which has been used. You find people on the shortlist. So, if the people who have been shortlisted, they don't know how they have come on the cause list. But maybe they know, because they have talked to some people in the back door. That is what the problem is. Now, others are discarded, others are taken for the interview. So they conduct interviews. Me, I have never applied, I have never gone for interview, but people tell me. So you go and sit an interview. Then after the interview, you hear, you see a list. But even the list, before it comes, there is always a stampede. Who is on the list, who is not on the list? So you find some people on the list, and then other people are not on the list. Recently, I asked the person who had made it to the list that how many marks did you score? He didn't know the marks he had scored even. So people are on the list, people have won, but they don't know how they have scored. People have failed, they don't know how they have scored. Imagine what kind of country is that one. People sit to be appointed judicial officers. They sit interviews. Me, I have never seen any exam where people sit and they are not told how they have performed. And recently, I was a panelist at the annual Royal conference it was at Munyonyo. I was a panelist at the same panel where there was the Deputy Chief Justice who has retired, Justice Butera. I told Mr. Butera that me, Mutabingwa, I have never failed any exam. If I applied to be a judge and then I didn't make it on the list, I would come back and ask what my performance was so that I see whether I have genuinely failed or I have not. But what do people do? Any person who has not made it on the list, they now apply afresh. He doesn't know how he has performed, but he makes a fresh application. Then he fails again. I know people who have failed 6 times. They want to be 6 times. Why can't you go and say and ask, why am I failing? Am I failing genuinely? Or am I passing and I'm discarded? So the problem is that now, if you say, now the Judicial Service Commission appoints advocates, the same problem is going to crop up. And you know, we have many advocates who are thieves. And now many thieves are crossing from the bar to the bench now. Because of the same system. Somebody, you find him on the list of the judges, and then even his colleagues, they are wondering, how has this person been appointed? But you see, people can't talk. They talk in smaller groups, in whispers. But the person serves as a judge, and me as an advocate, I'm supposed to say my road. That is what is happening. So if the Judicial Service Commission was genuine, they would make a transparent process. We have very many able advocates, very young, very clever, very bright, and even very competent, and even very honest. I cannot say that in this country everybody is not honest. No, we have very good people, very competent people. But the problem in this country, people who are competent, people who are honest, they cannot be appointed. That's what the problem is. So this problem, you cannot solve it like that. You cannot leave it to the Judicial Service Commission. It has already failed to appoint judges and judicial officers. You cannot now assign them this task. We shall go back to one. That's what the problem is. Maybe if the whole of the Judicial Service Commission is changed, and maybe we go to Kenya and we can import the one from Kenya, or we import from another country. But it cannot. That's what the problem is. Okay, maybe we need the intervention of God.
We need the intervention from the bar to the bench. But before we probe further on that, there are so many questions which have come in. I don't know how we'll take them. I see there are also people who are requesting to speak. I can see Mark is on requesting to speak. Maybe Mark, before we take your question, we'll first take the questions of some of the people. We'll hand around 2 or 3. Immediately there's someone called Teso Insurgent. I don't know what kind of insurgency. I don't know. Teso Insurgent seems to be a legal rebel. But Teso Insurgent is asking, what happens when administrators or executors have filed a lawsuit to recover estate property and the case is pending in court? Do they still, by implication of the law, lose the right to prosecute the lawsuit if they have not renewed the letters? So in the sound to protect estate property, if I understand Teso Insurgent's question, someone files a suit. Another question, so that's one question, maybe we'll take around 3. Alan Karugaba is asking that if a person with letters of administration or a grant of probate for the estate is a family member, but the assets are still in the name of the deceased, does this deadline apply? I think the quick answer would be yes. The deadline would apply. Louis Dramadri is asking, what's the state of affairs where the executor or any of the witnesses predeceases the testator? Does that invalidate the will? I think that's a question now about the will. And I think Yasin Sentumbe Munagomba is asking what happens to suits based on grants that expired. So a lot of questions around expiry.
The last one, so that you take once. This one says, just to clarify on the remedy, the grant issued in 1995. This grant was issued in 1995. I think shortly before I started practicing. So this does have still the same remedy of applying for extension. Just clarity on that.
Yes. Is that all?
Yes.
For now. So, the first question, people who have filed you have filed a lawsuit, and of course you are basing yourself on your letters of administration as an administrator, and then the grant expires. So what happens to the lawsuit? In my opinion, I have a few suits. I represented administrators, and the suits have been going on in court. I don't think the suits will expire because the suits have already started, and now they are before the competent authority, before the court of competent jurisdiction. Yes. The court is the one now to decide, because a case cannot expire because of the letters of administration, because they are already. And maybe I have not. I have not read the whole of this act. Maybe there is a section there.
No, maybe just to play devil's advocate before you go further. If you are suing as old or as administration, which have now become invalid, yes, they have expired.
Yes.
As counsel for the defense, I would say you no longer have locals. So that's I think that's why the person is asking that question.
Yes,
and as a litigator for very many decades, you could be
yes,
answer
actually,
that.
it is a very good question.
Yes.
Because you are basing yourself on the letters of administration, isn't it?
Yes, now
on the grant.
Exactly.
And the grant has expired.
Yes.
But you are before court already.
Yes.
But you see now, here I can reason. My reasoning is that since I filed the suit, or since the suit came into being before the expire of the what? Of the grant, then the suit cannot expire. That is my reasoning. Exactly. Yes. But somebody can bring a PO, by the way.
That's why I said I wanted to play devil's advocate, and I said no, you no longer now have powers to proceed. Sorry. Because
now on the suits we got cause of action, Order 7, the cause of action. The plaintiff must have a right. The right is violated, and the defendant is liable. My cause of action accrued when I had the grant of letters of administration. Yes. That is my reasoning, Edison and team. Yes. Then the next question.
The ones you had written, I think.
If a person is a family member and the property is still in the name of the deceased, isn't it? Of course. If the property is still in the name of the deceased, you have to use a grant. First of all, to put it in the names of the administrator. How would you put the property in the names of the administrator? By using the grant. Now the grant has expired. If it has expired, then you cannot use it. Then it means if there was an administrator who didn't do his work, his letters of administration have expired, then the court has to appoint another administrator. Another administrator has to be appointed. Or if he can act within these 8 days and apply for extension, and even by the extension, you have to prove sufficient cause. It is not just a matter of applying. You must show court, and even the beneficiaries have to consent. It is very serious now. Even you have to bring in the beneficiaries. They have to consent to your application so that you can be given an extension. It is not just a matter of applying for extension. No, even the people, the owners of the estate, the beneficiaries have to consent, and they have to be in court. Okay, I have seen even they are made respondents in all the applications. So they must appear in court and consent. If you don't consent, even you apply for extension, the court is not going to grant you the extension. So this one is not a hard question. It's clear and straightforward. You have to get a grant of letters of administration. Either you apply, if you have it and you have not used it, apply for extension within 8 days. Or if it expires, then another person has to apply for a grant. And then after the grant, you can put the property in the names of the administrator and divide it in accordance with the law. Then
let me see. This,
the state of affairs where the same thing. The suit has expired, and then grant has expired. Then the suit is pending. That one I have answered it already. Then a grant of 1995.
yes.
If a grant was made in 1995, of course it was made before the enactment of this Succession Amendment Act. Then it falls under this section, which I have already read. Under this section 341, subsection 2, a grant of probate of letters of administration issued by court before coming into force of this act. It will be after the coming into force of this act, it will be live for only 3 years.
Yes.
After 3 years, it expires. So he has only 8 days now to apply for extension.
Yes.
If he doesn't, then another administrator will apply and he will be granted letters of administration.
Yes.
Okay, maybe we have also some people who are requesting to ask questions. I think one of them is Mr. Mark Spector, and the other is that's otherwise known as Adit, and the other one is Sasi. Gentlemen, if you could ask your question in under 1 minute, we want to close in the next 10 minutes. We are keeping the same time as the letters of administration. Huh?
So start with Mark.
We'll start with Mark.
Thank you, Thank you. Thank you, Councillor Edson and Councillor Alfred, for this opportunity. Honorable Justice, I wanted to ask a question. During yesterday's session, which was hosted by Alfred, the Administrator General explained that you can only apply letters of administration. You cannot apply for them before they expire, for extension before you expire. And he seemed to talk about it to be a premature application. And the Act speaks of extension. It doesn't speak of application of new letters of administration. So he told us you must wait for them to first lapse. Today you tend to state that they can't be extended, rather one is required to apply for fresh. We want a clarity on that, on what's the correct procedure. Because also this argument has also risen when it comes to expiry of summons. Do you apply for new ones or do you apply to extend them? We want clarity on that. And my second question is like now. Also yesterday during the yesterday's session, the Administrator General talked about accumulation of letters that date as early as 1970, which is also going to create a substantial backlog. When you count from 1970, people have applied for letters of value way back. So I was asking, what's your say? Don't you think this is the ideal moment whereby Article 142 can be applied, where advocates are appointed as mission-based judges, since these are just application? I think this would be an ideal test for that suggestion that was brought about by Councillor Elson. Thank you so much.
Okay, thank you, Mark. And maybe before, let's also take Sasi's question.
Good evening, everyone. I hope I can be heard.
Yes, you
My
can.
question to the councils on this forum is: what's the legal position if administrators' letters of administration expire, but he had already conducted transactions, for example, land sale agreements, and a new administrator takes over. Are these previous transactions made by the previous administrator whose letters of administration expired binding on the estate? Thank you.
Thank you. Thank you very much, Sasi. I think we can take those two questions.
But this question is coming back. A very pertinent question, actually. As I have explained, do you apply for extension of time before the rate has lapsed or after it has lapsed? And the positions now seem to be two. Because I was in family court, according to the position of court, if the letters have expired, you cannot renew them. You cannot apply for renewal, for extension. You have to apply afresh. But now, as he's saying, the Administrator General says you have first to wait until the expiry of the what? Of the letters of administration. And I have already read this law, this section 54, which says that notwithstanding subsection 2, court may, on application, extend the period prescribed in subsection 2 for a further period of 2 years or another reasonable. So the issue is when is extension made, application made? Is it after the expiry or before? But according to us lawyers, if somebody has died, you might not apply to resurrect it. So that's why there is a stampede. Everybody now is trying to apply in these 8 days. And I think which seems to be the correct position of the law. Because me, I would think, if you have been administering this state, and you see your letters are about to expire, then you will be prudent and apply for extension and tell court, look, I am administering this state, but the time is not likely to be enough. The grant is about to expire. So can you grant me an extension? So in my opinion, I think the application should be made before the expiry, before the death of the what? Of the grant. But you shouldn't wait for the grant to die. So what would prevent somebody to make an application of extension when the letters are still valid?
If it expires, the application will be premature.
How is it premature? Because I'm telling court that in this remaining period, I will not have finished. I will not have finished the administering. And actually, in most cases, you find all the applications they come in one. Filing an inventory, filing an account. I didn't file an inventory. I didn't file an account. So now the grant is about to expire. Then I'm applying for extension of the what? Of the time to extend the time of the grant. So in my opinion, it should be made before the what? Before the expiry of the grant. But really, it will depend upon how court interprets this, because the law is there. The law is there. So any person can interpret it in either way. Like you have seen many decisions. Some judges are saying this, other judges are saying this. Like now you can see that the Administrator General is saying this, then other people are saying the court is saying this. So really, if court says that after the expiry of the grant, somebody can apply for extension, maybe it will be a sigh of relief, because the person can apply to extend any time he wants, even after 5 years. If your grant had expired, you can do what? You can apply for extension. But in my opinion, somebody should apply before the expiry of the grant. Then so somebody will say the suits to expire.
Yeah, it means that if has lost local standby,
Yes.
it will be lost.
I handled it because the cause of action was existing
Yes.
when the suit was filed.
No.
And the court, of course, court has inherent powers.
Okay, maybe.
No, the question I think from Sasi was about.
Actually, what I may add, when there is a case in court, then that is the opportunity now for court to determine all the issues. But it doesn't need to involve now to apply for what? For a fresh grant, and then you come to court again because you are already before court. And that is an opportunity for court to determine all the issues. Yes.
33 of the Judicature Act.
Court has got inherent powers to set all those ones. Yes.
But the Sasi was asking about whether a decision of an administrator made before the expiry, if there's a new administrator after expiry, whether the decisions of the administrator are binding.
Yes, that one is in the succession. No, although I don't have a section of it. Any act which was made by an administrator for the expiry or the invalidation, you have seen this one. When the court invalidates the letters of administration, any act which was done by the administrator is valid, including signing the sale agreements, including selling the property, unless there was fraud. If somebody was involved in the fraud, then that one cannot apply to him. But all actions done by the administrator before the invalidation of the letters of administration, they are valid. So if an administrator had signed an agreement, had made an agreement, that agreement is valid. But now the problem is going to be like this. You are keeping your agreement. Then there is a new administrator now. Maybe you have to file like a caveat on the land to make your interest known. But the law protects you anyway. The law protects you because you dealt with a proper administrator. We have so many cases in court. You find an administrator did something and then maybe they sued him. And like now I have a case in Ruero court. The administrators were there. Then they sold land to my clients. Then some beneficiaries sued and the letters were nullified by court. But court said all the acts of administrators which were done when the letters of administration were still valid, then the acts are valid. You cannot invalidate them. So this one is safe and the law protects him. Then somebody also is talking about the backlog of letters of administration and says from 1970, it is the same. We are going to have a stampede, and he was talking about Article 142. Yes, the Judicial Service Commission can do a lot, but it is not doing a lot. And even in appointment of judicial officers, it is not doing a lot, I'm telling you, it is failing. And that is what is bringing a backlog. So you give them another chance to appoint advocates, you will see the advocates whom they are going to appoint. You will see. You will see how we will be appointed. Okay, now
we have a lot of people who have joined us on TikTok. I'm told we're also on TikTok. And there's someone called Lawrence Yasona who says that we tell him the name of the person who is, he calls it addressing the media. I think the person who is speaking is Mr. Maxim Mutabingwa, a senior advocate of the courts. There's a question from Milton Mukisa. I don't know how to, it says, but how can an unknown beneficiaries grant mandate to current admins to renew the hold to the letters? How can unknown beneficiaries grant mandate? Okay, yes. Sorry. How can unknown beneficiaries grant mandate to current administrators to renew? So, yes.
Can I add one?
Yes, yes.
Okay, maybe to add one so that you answer them once. Regarding the suits in court.
Yes, yes.
This one flipped it the other way around, that I was the defendant,
yes,
and I was sued as the result of the state of the deceased.
Yes.
But now the letters have expired, but initially I didn't even want to go to court. So can I use that as my chance to say, now you no longer have powers to sue me because I no longer have letters of administration, they have expired. You get that logic. So what should the plaintiff do in that regard? That if you're the plaintiff, you say the person of administration. Now they have expired. Yes. So this one is saying, now you leave me alone. They have expired and not applying for renewal. I'm tired of these games of being in court. So what is the remedy for the plaintiff?
Okay. So somebody is saying, how can unknown beneficiaries now be privy to the application for extension of time, isn't it? because you have to involve the beneficiaries. Even the law says you have to involve the beneficiaries. They have to give their consent. But now this person says they are known beneficiaries. You see, the beneficiaries cannot be unknown. Or whether they are known beneficiaries, they are beneficiaries who are known. For example, when somebody makes a will, he puts there the beneficiaries. Those ones are already in the will. Then, even if there's no will, if somebody has died intestate and somebody is applying for letters of administration, he has to make a report of death to Administrator General. And in that report of death, there is a page where you have to put all the list of the beneficiaries. You know that person. Aha. So when somebody is applying for letters of administration in court, in a petition, you have to state the properties, you have to state the beneficiaries. So at least there are beneficiaries who are already stated in the petition. And those beneficiaries, even when you are applying for extension, you have to bring them on board now because they are already there. The court knows them. The court has your petition. So in the petition, they are the beneficiaries who are known. So those ones who are not known, maybe they can make themselves known when somebody applies for letters of administration and it is advertised, and he can lodge like a caveat, and he becomes part of the process also. So those ones who are in the petition, they are already known. Those unknown ones, when they see the petition advertised, they make themselves known and they file caveats and they become part of the process. So this one does not apply of unknown beneficiaries. Then this question is coming back again about letters of administration. Somebody has sued you. I'm the administrator. Somebody has sued me. And then I'm the defendant. Somebody has sued me, but I was the administrator when I was sued. So then you say, now my role is over. The letters have expired. But as I have already explained, at the time you were sued, there was a cause of action which had accrued already. And that cause of action still survives. It cannot die by the expiry of the letters of administration. It still accrues, and the court has to go on and determine the case against you.
Ferdinand asked his question, but before Ferdinand asks, maybe you had actually.
And by the way, I have never seen this scenario where somebody is an administrator and he's sued, and he said, no, you see me, I'm tired of the suits. I'm abdicating my duty, so I no longer want to defend. So let another administrator come, and then he takes his administration to court. I have never seen that episode. You have to stand and defend. You have to stand up and defend your suit until the end. So maybe it is the same scenario. So you cannot say that now my role as an administrator has ended. Now I no longer want to defend the suit. So you no longer have a cause of action. The cause of action has already accrued, and it is going on in court. The court has to go on and determine the matter.
Okay.
So what we're going to do, it's already 8:33. We are going to finish in the next 10 minutes. So we will have we have about 4 people who are lining up to ask questions. So I think each of them will have 1 minute. We have Mr. Sam Sechewa. We have Mr. Ferdinand. We have Martin Kagasira. And then we'll have the last question from Mercy. So, actually, those 3. I don't know if Mercy has any, she'll add if she has, but let's deal with those 3 questions. Gentlemen, if you could, we start with Sam Sechewa, just 1 minute. Then the son of Loyola, 1 minute. Martin Kagasira, 1 minute.
Ferdinand, could ask us Seshewa comes back.
Ferdinand?
Hello, good evening. Can you hear me?
Loud and clear.
Oh, thank you, Mr. Mtavinga, for the education you've given us. I have 3 questions, but they're very simple ones. 1, the law provides that the extension of time shall be according to the judge's discretion, the reasonable time that to be given. Would your interpretation be that the judge cannot grant an extension that goes beyond 2 years, or depending on the explanation given for why the estate was not administered for all that time, the judge can exceed 2 years, especially looking at cases like where you have a case in a court, you don't know it's going to end, or you are pursuing an ongoing compensation from government, would it be okay that the judge can give 5 years as a reasonable time, yet the law provides that the first grant should only be for 2 years? Secondly, we have seen in circulation some documents stating that there are exemptions to the limitation in time, especially when it comes to minors or people of an unsound mind. What could be your question? On the last point you made, which is very critical, if it is the administrator who has sued, and the only locus they have to go in court is because they are the administrator, does their suit abate upon the expiry of the letters of administration? Thank you.
Okay, Martin, 1 minute.
Thank you, sir. So mine has been asked on behalf of Miss Son of Loyola. You actually had a same view.
Thank you.
Thank you.
Ellison, I do have a question.
Please shoot.
I think just as you're parting shots at
This
the
is
end of
Mercy.
answering this time,
This is Mercy Makabai.
this is Mercy. Yeah, this is Mercy Makabe. Would like to always have solutions at the end of these spaces, and keeping in mind your experience and the fact that you're actually handling some of these applications. What recommendations, in terms of practical recommendations, would you recommend? Would you think that need to be implemented both by the judiciary and
Oh. Accidentally.
Then maybe
where the orders person have divided the asset among the beneficiaries, how would they report back to court? Is it real letter or notice of motion? This from Peter. I think those are the questions which were pending. You may shoot.
So I have two questions. I have, I think, three questions. The first two are by Ferdinand, then the additional one is by Masse. So Ferdinand is asking that can a judge, can a court extend the time for more than 2 years? Yes, the judge can extend the time for more than 2 years. The law is very clear. You see, that's why I came with this law. And you can see how it is becoming handy. Notwithstanding subsection 2, court may, on application, extend the period prescribed in subsection 2 for a further period of 2 years. Now, you hear, or any other reasonable time as determined by court. If it is satisfied that it is in the best interest of the beneficiaries to extend the period. B, the person to whom the grant of probate was made has complied with the provisions of this act, has obtained the consent of all the beneficiaries. So, Sir Ferdinand, court can extend time for more than 2 years, even if it is 10, as long as it thinks it is reasonable, or another reasonable time as determined by court. Here, court is given a leeway. It is given discretion to extend time to any time it wants, it deems reasonable. So that question is answered. Ferdinand, court can extend time for more than 2 years. He was asking, can a judge extend to 3 years or 5 years? Even if it is 10, the court can extend to 10 years. As long as it thinks, or as long as it deems the period reasonable. So, second question by Ferdinand was that upon the expiry of the letters of administration, then there is a suit. The suit was based on the letters of administration. Does the suit abate? Abatement of a suit. Abatement of suit. As I have already explained, the suit cannot abate because the letter of administration has expired, because the cause of action had already accrued, and the estate is for a court, and the court has to give a decision on that suit. So, Sir Ferdinand, the suit does not abate, and the abatement of suits also. If you read the the rule of abatement of suits, does not depend on the expiry of the letter of administration. Because in my opinion, my reasoning is that at the time of filing of the suit, there was cause of action. The cause of action means the plaintiff had the right is violated, you violated my right before I sued you. So my cause of action had already accrued. I had a cause of action, I had a right. Then you had violated it already actually. You violated it already. I'm not saying that you are going to violate my right. No, you have already violated it. When you are an administrator, then you are answerable for what you did. And then you are the one who is liable. You understand, Edison, and the team. So that's why a case cannot be abated because the cause of action was there. That's why even by the way, you are in the same vein. That's why acts of administrators cannot be invalidated by the what invalidation of letters of administration. As I have already explained, if an administrator was already appointed as an administrator and the letters of administration are invalidated by court, all the actions of the administrator, apart from fraud, they are saved. Yes, in the same vein, this cause of action survives and the suit cannot abate. Then Marcia was asking, she was asking and then she went off that recommendations, what can the judiciary do? What can the judiciary do? But she had not finished. But I understood it that now in the current circumstances, in light of this now, of this stampede, and which is going to create a backlog, what can the judiciary do? Because the judiciary now, it can appoint more judicial officers, but that one already, I have already told you there's a problem on the appointment of the judicial officers, and it is a big problem, and it is what is causing most of these problems. It is like a cobweb. You appoint an incompetent person, you know the effect of that, of the incompetent person. And these judicial officers, for them, they are not like us advocates. He's appointed and he knows he has his salary, he has his pay, until retirement, even after retirement, he's getting his salary. So it does not work, he's there. You see? Or he's incompetent. Or somebody is a thief. Somebody is a thief, he's a thief. You appointed a thief. And you should have done due diligence. And even the thieves are known, but you are appointing them. So it comes to the same thing. So the judiciary, yes, is doing well, but it has those shortcomings. And we advocates, that's where the problem is coming from. Everything now, by the way, me, I started practice in 1998. Things were good, I'm telling you. We practice through, I'm telling you. We practice through, you go to court and then you say my road. Things were moving. But nowadays, you go to court, you appear before a judge, you ask him, what is your name? He doesn't know his name, but he's my road also. What is your name? He doesn't know, but he's a judge. And it is affecting the whole country. Then judicial officers. Yesterday I was fighting in Kasangati. Criminal trespass. If you can see people who are in the prison because of criminal trespass and malicious damage, and those are land matters, and you see the president is saying these people should be on the land. Yes, the president has said they should be on the land. But are they on the land? People are paying, they are paying police, they are paying the state attorneys. These people are in the prison. Who will help them? So I went to Kasangati and I started fighting. They raised one. So who is going to help the people? Yes, it is good the president has the political will, but his foot soldiers, they are doing totally different things. They are running after money. So the recommendations, yes, we have the judiciary, we have the judicial office, I mean the Judicial Service Commission. But if they don't do their work they are supposed to do, we shall come to note. We shall not have any solution. That's what the problem is.
I think we still have so many questions, but I think it's now we are 15 minutes into the time we had planned to close. Let them ask questions. Okay, I see a question from Sasi. But Sasi, you had already asked a question. Okay, so let's hear from Sasi. Sasi had asked a question.
Okay, my question to council is Section 180 of the Succession Act. I don't know if it's still Section 180 after these changes. Grants the administrator power to manage the estate, and the estate of the deceased vests in him as such. But however, there is a recent judgment from the Court of Appeal, which is Dr. Diana Kanzira vs. Herbert Nankunda, I'm not sure the citation, that says that beneficiaries can sell their interest in the estate. I wanted to ask Council, how do you balance this? Doesn't this strap the administrator of his power in the estate? Do you think this was good law by the Court of Appeal, or this was a mistake?
Okay.
Allowing beneficiaries to sell their interest in an estate.
Thank you, Sasi. There's also a question, if I could just take this question very quickly. This is from Kelvin Augustine. What would be the way forward where the beneficiaries contest the executor or the administrator? I think he's asking in the context of expiry. If the grant is being challenged, and it's or the letters are being challenged by some beneficiaries, and then they are expiring, what would happen? There's also a question from Peter, where holders of letters of administration have divided the estate. How do they report back to court? Is it through a letter or notice of motion? And then there is a question from Benjamin. I think Benjamin is saying, if a letter of administration has expired, the appropriate course can be applying for extension, since there is no such a position of law from the Court of Appeal or Supreme Court. So I think Benjamin is just giving an opinion. There was a question where someone was asking about whether the application for extension is an ex parte application, and that means an application made only by the administrator, or does the administrator need to sue the beneficiaries? I think there was a question along those lines. Yeah.
Thank you very much. Starting with Section 180, actually, at that time it was Section 180, and I have also read this case of Diana Kanzira. I have it and I have read it. But see, what you must know is that this authority of Diana Kanzira did not take away the power of the administrator. It didn't. And you must know that each case is decided on its facts, and each case has peculiar facts. So what had happened in this case of Kanzira, there was land, and the beneficiaries had their portions. They had their portions. So each one had his portion, which was not in dispute. So one of the beneficiaries sold his portion to a third party. And now they were suing the administrator to validate the sale. And what court said? Court said no. The power of administrator is absolute. The administrator has authority to administer the estate. And even the court, I think it was Justice Bamgemerire, yes, in that decision, he said, I'm not taking away the power of the administrator, but the administrator should do his job. You understand? And actually, that's why now, that is what this Succession Amendment Act has come to remedy. You have letters of administration, people are occupying land of the deceased and they have their portions, but now they want to sell, but you are not interested, you are not helping them. So the person sold his portion, and the court said now the administrator should validate that act of the sale by the beneficiary, because he had sold his what? His portion, which is not in dispute. There wasn't any dispute. So why can't, actually the judge was asking, you got letters of administration in which year? Now these are how many years? When do you want him to benefit from his portion? You understand? But court categorically stated that we are not taking away the power of the administrator, but we can compel him to do his work. So validate that sale. You understand? And even as you can see, still it needed the validation of the what? Of the administrator. Give him, validate the act, and let the person, the third party, get title from you as an administrator, was not getting a title from the beneficiary. No, that's why now they were suing the administrator to validate the act so that the third party gets what? So I don't remember the name of the person who asked this. Sasi. No, the power of administrator was not taken away by this authority, but the court was urging the administrator to do his work, and the court can force the administrator, in the interest of justice, to validate the act of the beneficiary. That is what all this authority is talking about. So then somebody was saying, what is the mode of informing court after somebody has divided the estate and finished? That one is very clear. I have already stated, after getting letters of administration in 6 months, you file an inventory. Then within a year, you are supposed to file an account. And even the court has gone ahead now. I got these forms from the family court. They gave now the format of the inventory. Because, you know, many people, even advocates, they don't know how these things are made. So there is a format now, how to make an inventory. Then there is also another format, how to make the final account. So you file a final account. So after dividing the estate, you file a final account in court, and even the beneficiaries sign against what they have got from the estate, and then you finally wind up the estate. Then number 3, I was asking whether the application for extension is ex parte. The application for extension, actually, the first time I also applied for extension. Now I was wondering, how do I make this application? Who is the applicant? Who is the respondent? Now, whom am I going to sue? Now, this one just wants an extension. But out of my experience, now, no, I saw the beneficiaries must be made. I never consulted anybody. So I made the beneficiaries, the respondents. And when I reached court, I found I had done something right. So all the beneficiaries, you make them respondents. And you serve them, and all of them must come to court. If one beneficiary is not there, then you have to put him on Zoom. But they have to hear him. So that is now how court is very serious with this amendment. Even if one beneficiary is not there, they have to make him part of the process. Because administrators have been getting letters of administration, and they say the estate and the beneficiaries get nothing. So the correct procedure, what I have seen and what I have done, and what I have seen other people doing, is to make the beneficiaries respondents, and you bring them on board as beneficiaries, and you serve them. Otherwise, there is no way you can bring them to you can bring them to court. So the application for extension is not ex parte. You sue the beneficiaries. Yes.
Actually, is proposing that you come back another day and we continue, because maybe we'll come back another day and we have another. It's okay. So in that regard, you just answer this question and give us your parting shots. You shall come back another day. Kelvin Agustin is asking, who and how is the administrator or executor appointed? So just answer that, then we have your parting shots and we shall come back another day.
The process of appointing the administrator and the process of appointing the executor, they are different. Because the executor is appointed in a will. When somebody makes a will, he puts in a person who is going to dispute the estate as he has wished in the will. And that person is called the executor. So the executor is appointed by the testator, by the person who is making a will. And that person is the one who will go and apply for probate. So when the person who has made a will dies, the testator makes a petition, an application for probate. And he's the one to make it, no another person. And if he does not want to make it, then he has to inform court that he does not wish to apply for letters of administration. Yes, and then they can apply for letters of administration. Or if there are 3 executors and one does not want, then he writes to court, and then the other 2 can go ahead and get the probate. So they apply to court. After applying to court, for them, they don't go to Administrator General. If there is a will appointing an executor, they don't go to Administrator General. They make a petition. The petition goes to court. Then they are given a notice to advertise in the papers, in the newspapers, in the Gazette. Then if there's nobody objecting, the executor goes for identification and does the necessary procedures and is granted probate. Then letters of administration, somebody dies intestate or has a will which does not provide for an executor, he makes a petition for, no, first he applies for a certificate of no objection from the Administrator General, and the Administrator General calls a meeting of the beneficiaries, and they meet, they appoint a person whom they want to be appointed an administrator. The Administrator General gives that person a certificate of no objection. After that person has obtained a certificate of no objection, he applies to court for letters of administration through a petition. He presents a petition to court. The petition is received in court. Then is given a notice. He advertises a notice in the Gazette or in the newspapers, and they has to wait for 14 days. If there is nobody objecting, he goes to court for what we call identification. He's identified. He takes his identity card and his documents, and when they see that he's the proper person, they grant him letters of administration. So those are the different processes of obtaining probate and letters of administration.
For other questions, we shall have another wrap, as Mr. Sentumba has proposed.
So, cutting short, yes. So, we are practicing law. We have courts. Courts are helping us, but there is to be done. What we want from the judiciary and the Judicial Service Commission: appoint competent, hardworking, and honest judicial officers. The backlog is going to be reduced by 3 quarters. We shall remain with the small backlog. Actually, we shall not have any backlog at all. If the people who are appointed, they are competent, they are hardworking, and they are honest, then we shall not have any backlog. Actually, that is my view. The backlog is brought by those 3 problems of incompetence, of corruption, and of business. A person does not work, I'm telling you, a person is appointed a judge, but he does not work. Like in a year, he can decide like 3 cases only. And then he's also getting his salary. And that is what is where the problem is, I'm telling you. And even during the bar bench, I had given an opinion that the Judicial Service Commission should enhance the process of supervision of these judges and judicial officers. Look at how many decisions have been made how many cases have been decided. You see? If you don't do that, people don't work, I'm telling you. You know our work. Lawyers, I'm telling you, and what I can tell the public, if you have a child studying law and he does not want to work, that he should go away from the school where he's studying from. Law is a course of hard working. Wherever a lawyer is working, whether in chambers, whether in a government, in a department of government, whether in an NGO, all work is on your shoulders, I'm telling you. I have never seen work of a lawyer where the lawyer is not going to work hard. So now, now in the judiciary, when people are appointed judges and judicial officers, they think they have retired. Actually, they call it retirement. And they don't know that there is a lot to be done. Actually, becoming a judicial officer should be for very, very few people who have a zeal, who have the compassion to become the judicial officers. But now, people are becoming judicial officers for money. They know there is a pay there. The pay is good. But now, everybody, even who does not have any interest in deciding cases, he's applying so that he can get the what they pay. And he knows he has security of the job. So he goes there and then sits. He works haphazardly. They are in seminars, then there is a court vacation, then the year ends, then another one, then he's transferred to another place. And for us, we, the practitioners, we suffer. So let the Judicial Service Commission, let the judiciary help us. Otherwise, I wouldn't have another problem. Yes, the backlog will be reduced, or it will be eliminated totally. Yes.
Indeed, the dead are not dead, because the dead have kept us here for almost 3 hours. At this point, I know there are people who want to go and watch the United match when it's going to win its Europa League. When it's about to be relegated, but it's going to win. Like okay, that's all about to cover here finals. That's a story for another day. At this point, I want to invite Mr. Nelson to give his parting shots, and we maybe formally reinvite Mr. Max for another wrap. Mr. Nelson, over to you.
Definitely be having another wrap. Allow me to, on behalf of everybody who is listening, thank Mr. Mutabingwa for the time you've taken. I think we had promised you 1 hour, but it is now 2 hours that you've taken to really go through the concerns that many people have. We had said that we are taking a break from usual programming, as we called it, but it is clear that we've really also discussed the issues we always discuss here, the challenges we have with our court system, the challenges we have with the delivery of justice. On my part, I cannot express how grateful I am, Mr. Mutabingwa, for your time, how grateful I am for your taking a whole evening to sit with us and to really share with us from your well of knowledge and your depth of experience. And on behalf of everyone who has come, I can salute you, and I assure you we've had a good number of people who have come in, who have listened, who have taken note, and who you've actually helped, who you've guided, and whose advice you have given this time for free. I know usually this sort of information is chargeable, but you have opened up your store and your heart and shared with the public, and we are very grateful. We, of course, will continue discussing the issues that concern these spaces. We are a space dedicated to trying to shine a light on our judicial system and how it can improve. Our contention is that we have a lot to do, and that these discussions bring light into the conversation, and that light is the best disinfectant. Our contention is that we need to democratize and open up the practice of law so people can understand what's happening. Our contention is that we need, for example, to put back on track the issues of the Law Society. We need to ensure, for example, that the Law Society and members of the Law Society have an opportunity to elect their representatives to the Judicial Service Commission, as was envisaged in the Constitution, because the concerns you have had from a senior advocate that we have 3 problems: incompetence, laziness, and corruption. And these sort of concerns, these concerns are the concerns that the representatives of the bar must be advocating for in the Judicial Service Commission. And we shall continue to maintain that it is a massive scandal that that Judicial Service Commission is sitting without or if it is sitting, without the representatives of the Uganda Law Society. That being said, to everybody who has joined us, the only thing we can tell you is what we tell you, because we see people have joined us from all over the world. So good morning, good afternoon, good evening, and good night. And for those of society, our members, we always close with a song we dedicate to you. And we dedicate this song to you because when the time for voting comes, you must ask yourself that Afrigo question. Olimujawa musajja asinga nze.